Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question and answer session, please press star 1 on your touch-tone phone. Also, today's conference call is being recorded. If you have any objections, you may disconnect at this time. Now I would like to turn today's conference over to Mr. Bill Meyer. Thank you, sir. You may begin.
Thank you. Welcome, everyone, to Session 2 of the Intergovernmental Forms Training. I am Bill Meyer, an OCSE Program Specialist, and I will be the moderator for today's session. Jeanette Savoy and Debbie Ward will be your trainers. Jeanette was the supervisor of the Colorado Central Registry for 16 years and now works for the Center for the Support of Families. Debbie is a training specialist with OCSE's Division of Policy and Training. All three of us participated in the work group that provided input on the new intergovernmental forms. Today, you will have an opportunity to ask questions at a couple of intervals, and you can submit written questions in the Q&A section of the web presentation. We have a panel of OCSE staff on hand to assist in responding to your questions. If we have time at the end, we will provide responses to some of the questions from the first training session. Now I will hand it over to Debbie Ward to begin today's training.
Thanks, Bill. Welcome, everyone. The Intergovernmental Forms Training was set up to provide 4 90-minute training sessions over a couple of months. And all the sessions are held from 2 to 3:30 Eastern Time, except for Session 3, next session, which is from 2:30 until 4 Eastern Time. So on March 28, 2017, in Session 1, we covered the objective of the whole training course. We gave you some background information. We went over the general changes that were made across the forms. We went over 4 forms that are listed on your screen and the implementation timeframe. The Uniform Interstate Family Support Act is what UFSA stands for, and we'll be referring to this as UFSA for the rest of the training. So as we go through acronyms, we're going to tell you what they are, and then we'll use the acronym for the rest of the training. Today for Session 2, we're going to review the Transmittal 2, the Transmittal 3, the letter of transmittal requesting registration, and the Uniform Support Petition. We'll also cover the implementation timeframes again. So in Session 3, on May 16th, we'll cover 2 additional forms, and that'll be the general testimony and the request for change of support payment location pursuant to UFSA Section 319. And once again, we'll also cover the implementation timeframes. We're doing this so that everybody, we're getting different people sometimes in different sessions so that you definitely have what the implementation timeframes are. And then in Session 4, on June 27th, we'll cover the rest of the forms, which is the Declaration in Support of Establishing Parentage, the Notice of Determination of Controlling Order, and the Child Support Locate Request, and the implementation timeframes once again, and then we're going to wrap up the entire training session. So we'll be stopping at the end of the form, like if each form, for you to answer questions, like Bill had said. And the slides with the notes will be posted on our website like they were for Session 1. So you'll see that fairly soon after this training. So let's get started on Session 2. The Transmittal 2 provides a standard format for a 4D child support agency to request or provide additional information or services after an intergovernmental 4D case has been opened. The form is intended for use only between 4D agencies and may be used by either the initiating or responding 4D agency. As we discussed in Section 1, this form contains a header that's consistent across all the forms. So we're going to review just a couple of the details for the header. There's a checkbox at the top of the Transmittal 2 to indicate that the Child Support Agency confidential information form is attached. This form is not required for the Transmittal 2. However, you may need to include it, especially if you don't have the other state's 4D case identifier. Use the Notes section to alert other states if there is a nondisclosure finding or affidavit attached. If the transmittal form was sent through EDE, or if the request for information was sent through SESNet. Those are the three different check boxes. Do not use Transmittal 2 to make an initial case referral. As we discussed in Session 1 training, a Transmittal 1 is the form used to do initial case referrals. Next slide. So in Section 1, Case Processing Actions, this section has changed pretty extensively. We have distinguished between information that is being provided and actions or information being requested. So depending on the situation, the initiating or responding states might be providing or requesting information. Multiple boxes can be checked as appropriate. The details are provided in Section 3 or as an attachment, whichever is appropriate. If you're sending information to the other state's child support agency, such as a status update or an arrears calculation, indicate that you are sending using one of the 12 checkboxes in the Providing section, highlighted at the top of the slide. Many of the options are similar to the old version of the form, such as status update and notice of hearing. We've expanded the arrears checkboxes from the notice of arrearage reconciliation / determination of some certain that was on the old form to now indicate whether the jurisdiction is providing a month-by-month arrears calculation under Item 6, a payment history under Item 7, or an arrears balance and or accrued interest, also known as the Affidavit of Arrears, under Item 8. This revision was because the wide variance in state documents, especially payment records. Some state payment records have balances, but others do not. Some include only payment received in that state, while others include payments for which the obligor has been given credit even though they were not processed through the state's disbursement unit, or SDU, as we'll be calling it going forward. The payments such as direct payments of to the obligee or intercepts received by another state. We added Item 9, Notice of Health Care Coverage Change, to ensure that the other state has the most up-to-date insurance information, such as the health care provider's name and address. There's also a new checkbox under Item 10 to indicate that you are providing notice that the case has received an offset from the Federal Collection and Enforcement Program. This information is critical to ensure an accurate payment record and balance. If checked, the initiating and responding agencies need to take the appropriate measures to safeguard the information. This information is most often sent via SESNet, which eliminates the need to log and track the information. Check Item 11 if you are providing a nondisclosure finding or affidavit that was not sent with the Transmittal 1. As with most of the forms, there's an other port option, which is Item 12, to allow space for additional information. Next slide. Okay. If you're requesting information from a child support agency, complete the requesting portion of the Transmittal 2. Under this section, there are checkboxes in the highlighted portion of your screen. Again, these options will be familiar. We added Item 17, Administrative Review, for a contested debt certification in the Federal Collection and Enforcement Program. When an obligor has contested debt certification and requests an administrative review in the order-issuing state, the submitting state that has an intergovernmental case with the order-issuing state should use this form to ask the order-issuing state to complete the administrative review and provide the arrears balance. Use Section 3 to explain. For example, Kansas has initiated a case in Nebraska to enforce a Nebraska order. Kansas submits the case for federal IRS collection. The obligor does not agree with the balance, but wants Nebraska to do the administrative review, since they've enforced the order since it was issued. Kansas would do a Transmittal 2 to request the administrative review by Nebraska. As we saw on the previous slide, item 18, Other, allows space for additional requested information. There is also a new highlighted directive to please return the requested information. We've done that because the commenters during the forms review process identified this as an issue. Section 2, the Intergovernmental Case Closure Actions, is a new section that focuses on case closure information. The first part is from the initiating agency. In item 1, the initiating agency may notify the responding agency that it's closed its 4D case and the reason for doing so. The reason should be one of the case closure criterion noted in the Federal Case Closure Regulation. Upon receipt of such information, the responding agency must close its responding case. In item 2, the initiating agency may request that the responding agency close its intergovernmental case and stop income withholding. This checkbox is applicable when the initiating agency intends to keep its 4D case open but no longer needs the services of the responding agency. For example, if the obligor has moved to the third state, the initiating agency may decide to open a case with that state. If there are further instructions, these would be provided in Section 3. The second part is from the responding agency. In item 3, the responding agency may notify the initiating agency that it has closed its intergovernmental case at the request of the initiating agency. In item 4, the responding agency may notify the initiating agency that on the specified date, the responding agency intends to close its case because according to federal regulation, the initiating state has failed to take action, the actions necessary for the responding agency to provide services. According to the federal regulations, the responding agency must notify the initiating state 60 calendar days in advance of its intent to close the case. Therefore, the date on this section of the form should be at least 60 days from the date you complete the transmittal 2. Also in this section, identifying the requested information or documents the initiating agency failed to provide. In item 5, the responding agency may also use the form to notify the initiating agency that it's closed its intergovernmental case for failure of the initiating agency to timely respond. The Section 3, Other Pertinent Information, was renamed from Additional Information to make this section consistent with the other forms. It provides space for the jurisdiction to provide additional information that may be useful. If the information relates to a previous section, identify the section number and item number. For example, you would list Section 1, Item 2, and provide the date and time of the hearing. The lower part of the form notes the date the form was completed. It also provides the specific contact person's name, a direct telephone number, including extension if necessary, a fax number, and an email address. A direct telephone number, including extension if necessary, will expedite communication between jurisdictions. If a direct phone number is not available, then provide the best number. Note that the acknowledgement has been eliminated since the form is designed for use by both the initiating and responding 4D agency.
Thank you, Debbie. And that's our review of the transmittal number 2. We'd like to open up the phone lines now and take a few questions on that form, if you have them.
We will now begin the question and answer session. If you would like to ask a question, please press star 1. Please unmute your phone and record your name clearly when prompted. Your name is required to introduce your question. To withdraw your request, press star 2. One moment, please, for the first question.
And while we're waiting for the first question over the phone, we did get a question in writing. It says, where do you find the federal case closure actions? The case closure criteria are in the federal regulations, 45 CFR 303.11. Do we have any other questions on the T2?
Your first question from the phone lines comes from Andrew Moore. Your line is open.
Can you hear me?
Yes, speak up.
So our computer system, our child support computer system, is set up to automatically send the Trans 2 acknowledgement. From what I understand, removing that would be a good amount of work. Is there a way to replace our existing programming to automatically send an acknowledgement? Could we swap that out with just the Trans 2, or are you wanting to eliminate, like, acknowledging the receipt of a Trans 2 audit, like, totally?
I think you have some options there. The acknowledgement's not required at this point, so it might depend on which actions you're requested or provided. So I think you have some options there on how you proceed. Anyone else want to weigh in on that response?
Yeah, I wouldn't think it would. This is Jeanette from Colorado. Thanks. I wouldn't think it's harmful for you to send the acknowledgement as long as whatever information you need goes with it. But if it's just an acknowledgement and then you're going to respond to it later, especially, then I think that's okay.
Right.
Okay.
And of course, a lot of states are using SESNet transactions to communicate back and forth on case actions as well. So the Transmittal 2 is just another option.
Right. And then the existing acknowledgement has like Social Security number and stuff like that. So if we keep it intact temporarily, the idea is that we'll take it out in the future, but in order to get these forms working in time, we're hoping that we can leave something in that programming. So we would just have to make sure that the personal information and all of that is taken off of it. Whatever.
Well, that's a good idea, and certainly we recognize that there will be programming changes sort of across the board on these forms. So, and we'll talk about effective dates and some of that down the road. But yes, we understand it'll take some time to make these adjustments.
Okay, cool. That's all I have for that.
Thanks. Do we have any other questions? There might be
Your next question from the phone lines comes from Yahida Maganti. Your line is open.
Hi, yes. I actually submitted it through the chatting as well because I wasn't sure if I did it right to do it on the phone. I think I got the answer, though. The last sentence at the end of the PowerPoint said something was eliminated, and I'm assuming that's the acknowledgement form that we were just discussing?
Yes, the acknowledgement of the Transmittal 2.
Okay, I just missed that last sentence. Sorry. Thank you.
You're welcome.
As a reminder, if you'd like to ask a question, please press *1 on your touchtone phone, and please record your name clearly when prompted. One moment, please, for your next question.
Are there any other questions?
I am showing no further questions.
Okay. Okay, and we do have some online, but we probably need to keep moving, make sure that we get through our presentation materials. So I'm going to turn it over to Jeanette to talk about the Transmittal number 3.
Thanks, Bill. Hello, everyone, and welcome. You're seeing the Transmittal 3. You should be looking at Transmittal 3, Slide 1. We realize that some of you may be just looking at paper, so we're trying to kind of keep you appraised of where we're at. The Transmittal 3, of course, provides a standard format for a 4D child support agency to request another jurisdiction to provide just limited assistance. The form is intended for use when a jurisdiction is working a case locally, for instance, maybe using long arm, and does not want the other jurisdiction to open a responding 4D case. Both sections 316 and 318 of UIPSA contain specific provisions that allow a tribunal to receive evidence from another state and to obtain discovery through a tribunal of another state. The changes to the Transmittal 3 were done to more clearly reflect that the form is designed for limited services where there is no request for the initiating jurisdiction to open an intergovernmental 4D case. Federal regulations do require all 4D agencies to cooperate with the listed requests for limited services from another state agency, and we'll see those requests on the next slide. Not yet. Requests for other limited services may be honored at a state's option. The header record was again changed to be consistent across all the intergovernmental forms, as we've seen on all the forms we've looked at. And the form again only contains the party's name, but no other identifying information. You may need to include the Child Support Confidential Information form so that the assisting agency can correctly identify the parties. And if you do so, please mark that checkbox that you see there on the top of the slide. Note that this revised form does use the terms requesting agency and assisting agency rather than initiating and responding, to highlight that this form is requesting limited services and not services in an intergovernmental case, typically referred to, of course, as a two-state case. On to the next, slide 2. The first area on this slide provides the names of the children for whom support is owed or being sought. Section 1 is separated into 3 categories. And the first section covers the limited services that the assisting jurisdiction is required to provide upon request. The second section is used to request the 2 optional limited services, which the assisting jurisdiction may, but is not required to provide. And then the last section that you see in Section 1 is for the requesting agency to request payment forwarding to its SDU. So let's take a look at some of the specific requests, beginning with the mandatory limited services. Items 1 through 4 are self-explanatory and probably pretty familiar to most of you. So we're going to look at item 5, assistance with administrative review, and this is new on the Transmittal 3. You would use this checkbox when a state needs assistance from the order issuing state with an administrative review, but there's no intergovernmental case with the order issuing state. And you might remember, hopefully, that Debbie talked about using the Transmittal 2 if you do have an intergovernmental case. So this you would use only if that's the only service you want the order issuing state to provide. Item 6, assistance with discovery, is new language that just more expansively addresses discovery. On the old forms, it was called obtain answers to interrogatories. Item 7, assistance with AEI, is a new checkbox. This was added because federal law and regulations require states to assist one another with what's called high-volume automated administrative enforcement in interstate cases, called AEI. OCSE Action Transmittal AT 0806, that's 0806, defines AEI, which is typically used to lien financial accounts. Items 8 to 10 are for optional limited services, assisting with a lien, requesting financial data or proof of the respondent's income, or other requests that you might make. Item 11 is used to request payment forwarding from the assisting agency's state disbursement unit to the requesting agency's SDU for disbursement. Such a request may be appropriate when the payments are going to the assisting agency's SDU and the custodial parent applies for services with the requesting agency. A payment forwarding request on a Transmittal 3 is not a request for the assisting agency to open an intergovernmental case. It's simply a request for the assisting agency to forward payments to the requesting agency's SCU. This option was added when the forms were under review at OMB, as several comments were received requesting a payment forwarding action. And then you see the date when the requested information is needed, and that's been moved from the header to the end of Section 1, and it's now called Response Needed By. You see that right at the bottom of the slide. This might be particularly important if you're needing something for something time sensitive, like you have a hearing coming up and you need the information before the hearing. There were 2 checkboxes that were removed from the old form. One was to obtain a party's signature on an attached form. In the work group, we heard from states that this was rarely needed and could be included under other if it was needed. And the second was file a determination of controlling order with the order issuing tribunal. This is now included in the revised notice of determination of controlling order form, and of course, a determination of controlling order is rarely necessary because it occurs only if there are still 2 orders with current support due. Now on the Transmittal 3, slide number 3, sections 2 and 3 didn't change much. They look pretty much like they did on the old form. In section 2, we did change the title from additional information to other pertinent information. And the checkbox verified address of employer was removed, as that would now be on another form. The checkbox for non-disclosure finding or affidavit attached was moved to the form heading to be consistent and then renamed as we have it on the header. In section 3, we did change the signature from initiating contact person to requesting contact person to be consistent with the rest of the form. Again, a direct telephone number, including extension if necessary, will expedite communication between the jurisdictions. If a direct phone number is not available or you're precluded from providing that, then provide the best number that you can. Now on the next slide 4, we see the Transmittal 3 acknowledgement. It does still have an acknowledgement, and essentially it's the same as it was on the prior form, so there are no substantive changes. So I will turn it back over to Bill now for questions.
Thank you, Jeanette, and we'd like to open up the phone lines again to take any questions that you all might have on the Transmittal number 3.
As a reminder, if you'd like to ask a question, please press *1 and please record your name clearly when prompted.
And while we're waiting for the first question over the phone, I did have a question online. It states, for purposes of requesting a change in payee and case identifier in response to an administrative redirection of payments, should we use Trans 1 or 2 on an existing case? And perhaps someone might want to clarify that. I'm hoping that a discussion of the Transmittal 3 maybe answered that question as well. Transmittal 3 allows a request for payment forwarding, and certainly in future discussions we'll talk about the Section 319 and a change of payment location.
Thanks, Bill. This is Liza Lowe in the federal office, OCSE.
Yes.
Yes, because it's an existing case. On existing cases, you always use the Transmittal 2. So that's what we would recommend. And then you want to clearly, very clearly state what your request is. It's not entirely clear what that request is to us. So you would just want to do that clearly on the Transmittal 2. Excuse me.
Right.
Liza, the other thing I would add, this is Jeanette, change of payee is used to mean so many different things. So I think if what you really have is a new obligee, then you want to check with the responding state to see, do they need a new Transmittal 1 because they're going to open a new case, or do they just need the information on a Trans 2 to add to their case, if that's what you mean by change of payee.
Thank you. We've covered a couple of bases there. Certainly the Transmittal 3 is when there's not an existing case, and the Trans 1 is to open up a new case, and the Transmittal 2 is for subsequent actions on an existing intergovernmental case between 2 states. Do we have any questions on the phone?
I am showing a question from Eleanor Tate. Your line is open.
Hello, I have a question. The payment locator code, is that the FIPS code?
Yes, the locator code. Yeah. Sorry, Bill. Locator code is it was changed. FIPS code was changed by the federal office to locator code several years ago, really to encompass tribes and other countries. So the term locator code is what you'll see now.
Thank you.
And I am showing no further questions at this time.
Okay, we have one other question online. What should a requesting state do when we submit a Transmittal 3 requesting payment records and the assisting state will not process the request unless we send a Transmittal 1? Well, of course, there's a number of different scenarios there. and why they wouldn't process it would be an interesting question. But again, Transmittal 3 often used for situations where there's not a referral between the two states. So if you already have a case set up, you would probably use the Transmittal number 2. If you're just wanting a payment record and you don't necessarily need to open a case with that other state, you can send the Transmittal 3, but you might actually have to call someone and talk to them about and find out what their situation is and how they would come up with a payment record for you. If there are no other...
Bill, this is Pat Crawford. One other comment. Requesting a payment record is fairly easy. You don't have to have an open case. You can do it right through EDE, so you can make a request. And, obviously the other part about if the other state isn't going to provide it, but, we do help with some follow-up. So you don't need to use any of the transmittals to request a payment record if you and the other state are both using EDE.
Thank you, Pat, and that's a good point. A lot of these forms are making way for some electronic communications in the future, and we'll probably be seeing more and more of that.
I am showing 2 questions from the phone lines. The first one comes from Billy Joe Raymond. Your line is open.
Yes, I'm wondering, when we're requesting a limited service case for, filing a trustee process against a bank account, a lot of states don't do limited service actions. We have to file a whole case with them. And from reading this Transmittal 3, it sounds like all states are supposed to provide some sort of limited service without opening up a whole case, but we're running into some issues. So I'm just wondering if that's really true or if it's based on maybe that state's law.
Well, there are a lot of complications with interstate policy and coordination and what one state's able to do or not. Certainly we're focused on the forms today, and that first section of the Transmittal 3, those are directly from the federal regulations as far as the limited services that are outlined there. But often it takes some communication and working with the other state to sort of get the action processed.
Your next question comes from Jesse Archambault. Your line is open.
Hi, my question is whether the Transmittal number 3 is the form that tribes would use to request another state provide information about a non-custodial employer, and if so, is it if you could tell us what box we would need to check and whether this is mandatory or optional.
Well, the Transmittal number 3 is not mandatory for any particular situation, and I'm not sure that, certainly for the tribes, I'm not sure that you have to use these forms. And as far as the non-employer's information, if you're asking for just some general information, I suppose you could use this form and check other, but it may be best to contact someone in another manner to get what you really need.
So are you asking for employment information on an obligor? Is that what you're asking
Yes,
about?
that's what I said. I thought I said, sorry.
Yeah, that's what I thought, but I think you could use this form. I don't see why you would not be able to, but you certainly would need to send the confidential information form with it so that they'd have the Social Security and all that. But you could also use it, which might be better, would be the locate data form, which we're going to get to in the last section. I think that might be better as I think about it.
Right, and from here you'd probably have to check the other box and explain what you're looking for, et cetera, and then, hopefully get some
that makes sense. All right, thank you.
You're welcome.
I am showing no further questions at this time.
Okay, very good. Let's move on. We're going to discuss the letter of transmittal requesting registration, and I think Debbie will take it.
Yes, thank you. We're on slide 1, and a letter of transmittal requesting registration is a required document used by the initiating jurisdiction to request that a responding jurisdiction register an existing order issued by a tribunal in another state for enforcement and or modification in the responding jurisdiction. The form is used in 4D as well as non-4D child support cases. The letter transmittal requesting registration replaces the old registration statement. UFSA requires a letter of transmittal when requesting registration and enforcement of an order issued in another state. UFSA also requires the same procedure when registering an order and issued by another state for modification. The letter of transmittal requesting registration fulfills this requirement and provides the essential elements of the out-of-state order the petitioner seeks to register. The title was changed to clarify this and to match UFSA. The action portion of the header adds a new checkbox to register the order, to enforce arrears only, and with sub-boxes to indicate whether the arrears are assigned and or non-assigned. It also adds a new checkbox to register the order for both modification and enforcement. As a best practice, a state should not ask for modification only if the obligee is in the state that is going to modify the order. The rest of the header record was changed to be consistent across all the intergovernmental forms, as we've discussed. This is the only form that still contains personally identifiable information, or PII. OCSE retained the PII information so that it can be a standalone form meeting the specific requirements of UFSA, which details the procedure for registration. However, the form does not ask the tribunal not to file the form. It does ask the tribunal not to file this form in a public access file. So moving on to slide 2, the case summary section provides information about the support order that is being transmitted for registration. The information includes the date of the support order, the state and county or tribe issuing the order, and the tribunal number. Under tribunal number, you may enter the docket number, cause number, or any other appropriate reference number that the initiating tribunal has assigned to the case. There are new fields to identify the type of current obligation and type of arrears broken down into child support, medical support, and spousal support. Enter the dollar amount and frequency of all current obligations and all type of arrears as appropriate. Notice that the form also includes a field for total interest. Use the other space to identify any additional types of support or arrears that are not listed. For example, under current obligation, other may include separate obligations such as child care costs. At the bottom of this section, there is space for the total amount of arrears and the period of computation if enforcement of assigned arrears only is being requested. That amount is identified in the assigned arrears only field. You will need to match documentation of the TANF time periods. Arrears are distributed based on whether they are due to the family or a state. So on slide 3, sections 2 and 3 have new titles referring to the obligee and obligor information instead of mother and father to make the form gender neutral. In section 2, there are new checkboxes to indicate whether the obligee is a parent or a caretaker. If the obligee is a caretaker, there's a space to indicate the person's relationship to the child or children and whether the caretaker has legal custody or guardianship of the child or children. Similar to the old form, section 4, other pertinent information, includes space to indicate whether the order has been registered in any other state as required by UFSA, attach a description and location of any property not subject to execution. There is a new line item to identify any source of income of the obligor in addition to employment. This and the other field allow the initiating agency to add other information that may assist the responding jurisdiction in its effort to register and enforce the order. The non-disclosure checkbox was moved to the form's header section to be consistent with other forms. Now on to slide 4. Section 5, attachments, is new and identifies the type of attachments necessary to successfully register the support order. Section 6, the declaration, has a new title, which reflects the fact that USO 2008 no longer requires a verified petition or a notarized signature. USO 2008 requires only that the petition be signed under penalty of perjury. If the person requesting registration is represented by a private attorney, there is a line entry for the attorney's bar number and signature. Now back to you, Bill.
Thank you, Debbie. That concludes our review of the letter of transmittal requesting registration. We'd like to open up the phone lines once again for any questions on that form.
As a reminder, if you'd like to ask a question, please press *1 and please record your name clearly when prompted. One moment, please, for your next question.
And while we're waiting for a question, I do have a question online, maybe a couple. The first asked, to my knowledge, Michigan doesn't have access to EDE. When or if will this be implemented? And that's sort of a state decision and choice, and Pat, you can chime in if you wish. I believe that's something that's an option for all states. You just have to sort of do the programming and get it set up within your state. So you might contact your state central office to get that more information about that.
Yeah, they can. Anyone interested can call their technical support representative or the help desk. There's no coding required for EDE, but your state does have to sign up for the program. You don't have to be able to send all documents. You can choose which ones your state wants to sign up for. So many states are now considering EDE, especially in light of some of the new forms that we're discussing today.
Bill, while we're waiting for a question, I just want to clarify one point. Debbie made a little goof. When you talk about a best practice, a state should not ask for modification only if the obligor is in the state that's going to modify the order. And Debbie, unfortunately, you said obligee. And in case there are new people on the phone, especially, I don't want that to be a letter of or point of confusion. So if the obligor is in that state, you would typically ask them to modify and enforce.
Thanks for catching that, Jeanette.
Yeah.
Do you have any questions on the phone?
I do. Your next question comes from Andrew Moore. Your line is open.
Hi. I was just wanting to get more guidance on the very last bit of Section 1 where it says attach documentation of TANF time periods. What exactly are you looking for? And if we create kind of a uniform sheet for our caseworkers to use, what kind of information will have to be on that sheet?
Well, it's actually what the other state would probably be looking for, I think, and the states have different requirements and sort of needs in that regard. So I'm thinking perhaps even just the time period, of course, when the TANF started and when the TANF ended, and perhaps even a monthly breakdown of the TANF payments would probably cover most situations.
So would it have to have I guess we would want to create something that's in compliance with these forms. So if we create a uniform sheet, should it have, I don't know, what do we have to put on this to comply with the forms requirements, I guess?
Well, Bill, I remember talking about this in the work group, and really I think all the other state needs is the time frames, what month to what month. Because the amount really doesn't matter because you go by the amount of the order. So I would say all you need is the time frames.
Which is on the form itself, so you just need to, complete the form.
But there may be, because people go on and off TANF a lot,
right.
I think that's what he's thinking, is there may be, you may need to attach something if they're different, multiple time frames.
Yes, that would be very helpful.
So I guess if we just create a form that has TANF time periods and it's blank to blank and there's 10 of those and we manually fill that in, does that satisfy that requirement? Or I guess I don't want to create something and then have it not comply with the form, what the form.
Well, I think it's just conveying information too. So, I mean, as long as you're conveying the information requested by the form, which is the period of, you know, the TANF periods, I think you would meet the requirement. A lot of systems probably track that already with regard to when a person's on TANF and when they go off and then when they go back on. So it's probably something your system already has in it, I would think. Does that help?
Yep. Yeah, that's good.
Okay. Do we have any other questions on the phone?
Yes, your next question comes from Antasy. Your line is open.
Yes. Needing to know, is it required, we haven't been able to locate anything on the website, is it required that there's a registration statement for each and every order with the new or the old forms?
Depending on what you're asking, if you're sending a request to another state and you're going to be asking them to register and enforce, then you would need the letter of transmittal requesting registration. Maybe I'm not understanding the question, but so if you're sending an order to another state and it's not their order, and they may need that letter of transmittal requesting registration to enforce or to modify or take any action on it. Certainly states are different. Some states do administrative process before they have to register. You can certainly check the IRG or check with the state to know for sure what they'll need right away. But usually if it's another state's order and not the responding state's order, you would usually send the letter of transmittal requesting registration.
No, actually, I don't think I made my question clear.
Okay.
What I'm asking is that for one court case, if there were 12 orders per se, we have a few states that are rejecting some of our things because they're stating that we need to send a registration statement for each and every one of those orders within that court case number.
So are those modifications?
No. Well, I mean, yeah, in some instances they are modifications. Some instances they're just, judgments that were taken for, the add arrears payments, things of those nature. But what's happening is that we're being told that we need to provide a registration statement for each and every order within that court case number when we send over. Now, typically, with most of the states that we do work with, there's just one registration statement that's sent over.
That's correct, and oftentimes one order and one cause number with multiple modifications, perhaps under the same cause number, and one letter of transmittal requesting registration should work. So it's maybe a little bit of an unusual situation. You'll just have to work with that state to see exactly why they're asking that and what you can provide to help them out and get it moving forward in their court system.
Sure. Thank you.
You're welcome. Any other questions on the telephone?
Yes, your next question comes from Sherry Hunt. Your line is open.
Hi, I just have a question under Section 5 about this order determining arrears. Is that a requirement? Because our county in Michigan does not do orders determining arrears. That's part of your certified arrears statement.
No, it's not required. It's just if you have one, if there happens to be one. So there are other states that in various judicial actions, you may end up with an order that sets the arrearages. And if so, that this is a place where you can provide that information.
Okay. Thank you.
You're welcome.
Next question comes from Lori Garcia. Your line is open.
Yes, what do you send with the transmittal requesting registration when you already have an open interstate case and your state has modified the order and the other jurisdiction is asking for a new registration statement with that newly modified order?
I guess my first thought is you would probably send the transmittal number 2, additional information.
Okay.
And I'm not sure there was a checkbox that worked for that, but you can always put other. Because you have an existing case, right, and it's the initiating state's order that's now been modified. You want to send that on to the responding state so they can sort of get that modification updated in their system, perhaps even registered there for enforcement. Is that your scenario?
Yes.
Okay.
And I've had states request, say they need another Trans 1, even when our state are already open with each other.
Right. So, yeah, a lot of variation in what states might need here and there, and certainly you could talk to somebody about what it is they really need. Again, my thought would be the T2 would be sufficient since you already have an existing case.
And, of course, a certified copy of the new order.
Right.
Thank you.
You're welcome.
Your next question comes from Trevor. Your line is open.
Hi, I noticed in section 5 on the Transmittal 3, it was still recommending 2 copies of all attachments in addition to the original, and I thought that was something we were trying to get away from with the EDE. Can you explain a little more about that, if that's just something that's recommended?
Jeanette or anyone else want to take that?
Well, UFSA still requires, are you looking at the Section 5 attachments?
Yes.
2 copies, including 1 certified copy of the order. That's still in UFSA. Now,
so the EDE part doesn't cover it?
Pardon me?
If we were to send something through the EDE in addition to the original paper copy, that doesn't satisfy UFSA?
I think it might. I think it would depend on the state that you are sending it to.
Okay.
I think the best thing I would say is call or email the central registry in that state and say, here's what I'm doing. Will this satisfy you? Because it's much easier to just communicate and find out for sure, because the answer is going to be different from state to state.
Okay, thank you.
And I am showing no further questions at this time.
Okay. We do have a couple of questions online, but I think we'll move forward and we can take those at the end if we have some time remaining. We have one more form to get through, and I believe we're going to be talking about the Uniform Support Petition.
That's correct, Bill. So the Uniform Support Petition is a legal pleading that you need to initiate an action in a responding tribunal. The personal information form for UFSA Section 311 must be attached, since this form will be filed with the tribunal, and you can see that requirement at the top of this slide on the form. The purposes of the Uniform Support Petition are to assert that the tribunal has jurisdiction, to show enough facts to notify the respondent of the claim being made, and to provide the petitioner with a means to request specific action or relief through the tribunal. Under UFSA Section 301, a petitioner or a support enforcement agency may initiate a UFSA action by filing a petition. Section 311 does require that the petition specify the relief sought and that 4D agencies must use the federally mandated forms. I don't think that would be a surprise to any of us. Though the Uniform Support Petition does remain a necessary form required to file a legal action in an intergovernmental case, the substance of the form is really largely unchanged from the old form. The petitioner is the person bringing the current action, and the respondent is the other party. And we have lots of discussions about this in the work group, and we do recognize that the designation of petitioner or respondent is a state system or state pleading issue. So OCSE added checkboxes to the header to identify the petitioner and respondent as the obligee, of course, the person to whom support is owed, or the obligor, the person who owes or is alleged to owe support. And we thought this clarification was needed because either the obligee or the obligor may initiate a UFSA petition. The rest of the header was again changed to be consistent across all the forms. And the children listed in the form are now right at the top of the form, or the children listed in the action. And any additional information is provided on that UFSA Section 311. Only the names go on this form. On to slide 2. At the top of this slide, can you move on? Thank you. You can see Section 1 action, which lists the actions that the petitioner might request. And you're going to check as many as appropriate. The options might include establishment of parentage, and notice that we revised the term to use parentage, which recognizes all families rather than paternity, establishment of an order, and this form does clarify that establishment of an order for spousal support is not a 4D function, modification of a support order, and other remedy sought, and then you would fill that in. The determination of controlling order and arrears reconciliation was removed because cases with multiple current support orders are extremely rare. However, as we talked about before, you might include a request to determine the validity of an order under other remedies sought if you think there's a valid order and a void order. On the lower portion of the slide, Section 2, grounds for supporting the remedy sought in Section 1, is used to support the requested action. This section did include some changes. To support a request for establishment of parentage, there's a new checkbox indicating that parentage for the named child or children has not been established, and as always, you would need to include a declaration in support of establishing parentage for each child. Recognizing that the petitioner may be the obligee or the obligor, this section was revised to state that the parents owe a duty of support. And if retroactive support is sought, to check the appropriate box to indicate who has not supported the children and when such support ceased. There's also a new checkbox that reflects the 3-year federal time frame requirement for review and adjustment. If the last review or modification was completed at least 3 years prior to the current request, no other grounds for a request for modification are required. Of course, since one of the most common bases for a request to modify is a change in circumstances since the order was entered or last reviewed for modification. And of course, you would want to explain the change in the space provided. There's also a new checkbox when the basis for the remedy sought is not listed on the form, and under additional grounds, you can add any additional information. And on slide 3, here you see a new Section 3, and this is a totally new section related to the Service Members Civil Relief Act, which provides the information that the U.S. Code requires a petitioner file with the tribunal before the tribunal can enter a default judgment for the petitioner. Providing this information on the petition could avoid a delay later if the respondent does not appear. So that's why we added it. The petitioner or 4D agency should indicate whether the respondent is in military service, and if you're unable to make that determination, check the last box. Also, you would use this section to detail any facts supporting that statement regarding military service. Be specific when listing the facts. And if you're unsure what exactly qualifies as military service, there are specific instructions in the instruction to the form. If the Service Members Civil Relief Act website was used to determine the respondent's military status, attach a copy of the results. On to Section 4 there on this slide, other pertinent information was renamed. It used to be called additional supporting information. And of course, you would want to check the appropriate boxes to indicate the documents being sent with the petition. The attached documents are incorporated into the petition. If you're sending forms or other documents with the petition that are not specifically identified in this section, be sure to mark other box and list the forms. And on slide 4, Section 6 is the declaration, was renamed from verification. And as we saw with the letter of transmittal for registration, the new title reflects that UFSA 2008 no longer requires a verified petition and requires only that the petition be signed under penalty of perjury, so the form no longer requires a notary public. I did see a question come up, do you have to have a notary commission to file UFSA cases? And the answer to that is no. The notary is no longer required on any of the forms. In a 4D case, the Uniform Support Petition may be signed by the person seeking relief or the 4D representative. And this form provides a checkbox to indicate who signed the form. And I'm not sure we've said, of course, the transmittals are all intended to be used just between 4D agencies, but the petition and the letter of transmittal for registration can be used in a non-4D case also. We did have a suggestion to change the signature field to petitioner or respondent, but the work group decided not to make that change. The Uniform Support Petition will always be signed by the person seeking or petitioning for relief, so the reference to petitioner we felt was appropriate. And as with the form we just saw, if the petitioner is represented by a private attorney, there's a line for the attorney's information. And then the last slide talks about the effective date of the revised forms. And you might be wondering when you must use these revised forms and when you might start receiving them. We do know that some states have begun programming for the revised forms, so you might receive them at any point if you haven't already. They are valid now. The deadline for all states to begin using the revised forms is January 15th, 2018. The delayed date is to give states time to make these programming changes. Until then, the old forms are also still valid and should be honored. And Bill, I'm going to pass it back to you.
Thank you, Jeanette. That concludes our review of the 4 different forms for today. We'll open up the lines again and take any questions that you have.
As a reminder, if you'd like to ask a question, please press star 1.
I do have an online question that asks about does the information from the automated system fill in the form data when generated, and of course that's dependent upon each state will program to complete these forms and generate these forms and pull the data that they can. I'm sure. So that's a sort of a state question about how you're going to generate the forms and how you'll pull the data and which data you'll pull. I think a lot of states will probably pull the order information. That's what was asked about. Any telephone questions?
One moment, please, for your next question. Your next question comes from Elaine Tuttle. Your line is open.
Hi there. This is really about the registration statement, and again, this may differ based on states' requirements, but what if the order is the responding state's order, but the responding state has closed its case, and now the obligor has moved back into the responding state, and you'd like them to reopen their case and enforce their order? What form do you use, or is that really dependent on the responding state's process?
Well, you shouldn't need the letter of transmittal requesting registration because it's still that state's order, correct? So you're wanting to open a 4D case, you would send the transmittal number 1, and that may well be.
And other, like, please reopen and enforce existing order type?
Yes, I mean, I don't have the transmittal 1 in front of me, but I think there's something on there that specifically says enforce your own order.
Right,
so that's what you would send.
Order. I also wanted to jump in there. We are working on a chart that shows you, because I see we have another question about this same issue, that will show you the forms that would be required for each type of case and the forms that would also be recommended. And we've just started working on it. So
like the UF, to replace the UFSA forms matrix?
Yes, because that one I haven't seen in a long time. I think it was out there at some point, yes. But yes, it's similar to that. So We're working on that, and hopefully at least we'll be able to provide it in draft form before too long. But again, if you're unsure, call the other state where you're sending it and say, what do you need? That would be my recommendation.
Okay, thank you so much.
Right, and a question along those lines online, is the complete UFSA packet needed for registration or just the Trans 1 and confidential information form? Well, you would probably need the other, the UFSA 311 form as well if you're opening a new case and requesting registration. But yes, you wouldn't necessarily need the general testimony and the uniform support petition. We also have a question about parentage. Other than paternity, what other parentage is there to establish? Shouldn't it remain paternity to stay consistent with 45 CFR 303.5? And I think it's just terminology there, so I certainly understand that paternity is what needs to be established in most cases. You know, I think that's just terminology, and nothing has really changed with regard to the need to establish paternity.
But Bill, one of the reasons we changed it to parentage is because we're now starting to have cases with 2 mothers where you need parentage against one of the mothers. That was part of the response to that.
Right, and a lot of that's very new, and a lot of state laws will probably be trying to keep up and make changes along those lines. We just want it to be a little forward-thinking.
And this is Ann in OCSE. UFSA uses parentage throughout the Act, and we were making the forms consistent with USSA throughout. So that's another reason for the change.
Thank you, Ann. Are
Your
there any
next
questions
question from the phone lines comes from Courtney Garnand. Your line is open.
Hi, it's Courtney Garnand. I just had a quick question. I've been looking at the instructions on all of the new UFSA forms, and I'm noticing if they're sending the forms through EDE, you mentioned that the supporting documentation should be sent through EDE whenever possible, but if certified copies are needed, hard copies should also be sent by mail. And I believe that OCSE sent out the information memorandum 1602 to clarify that the new UFSA 2008 does not require the hard copies because certified documents through electronic means are acceptable. So I'm wondering, is that a requirement, or because it reads as if it's a requirement to send that, so it's kind of mixed messages. So I just wanted a clarification, please.
Is there someone who would like to take that one?
I would just say it's going to depend on where you're sending it, and even though we in the 4D agency may say the electronic version is okay, the court may not. So I think that's where still, in some cases, you do have to send the paper copy. And, of course, there are still many states not using EDE.
This is Ann at OCSE as well. USSA clearly has a preference for electronic transmission wherever possible. And I believe IM 1602, which you referenced, spoke to that principle throughout USSA. With that said, as somebody mentioned, I don't have the site right in front of me, but USSA still does require one certified two copies of the order, including one certified, to be sent when you're sending the letter of transmittal requesting registration. So, so that requirement is there. However, as much as possible, the hope and the principle is that documents will be sent electronically.
Right. So that's what I guess I'm confused about, because the electronic copy of the certified document should be considered certified and valid. So you wouldn't need the actual paper copy, especially since so many states are going electronic now and doing e-filing.
Courtney, hi, this is Pat Crawford. I understand, and we understand what you're saying. I think the issue is, as Jeanette mentioned earlier, it's really all about what the receiving state will accept, and if they're still requiring a hard copy, a certified copy, then that's what we need to send. What we recommend to states is that if you're going to send the court order through EDE, it allows the state to get started earlier on all of the other case processing that needs to occur. But if they have to wait for a certified copy to proceed, then that's, when you want the state to follow up on that action, that's what we need to accommodate.
Thank you, Pat. Are there any other questions on the phone?
I am showing no further questions on the phone line.
Okay. We do have some questions that were left over from session 1, and we'd like to kind of go through those, or a few of those, and then we'll open it back up toward the end here. I think we have a few minutes left, so we'll give you another chance to ask questions on this session, but we'd like to go through a couple of questions from session 1. And the first question, Debbie, when do you use the Child Support Confidential Information Form and Personal Information Form for USSA 311? And so I think some confusion about when to use which form.
Right. There seems to be a lot of confusion around that. So first, the Child Support Agency Confidential Information Form is required for the Transmittal 1, the Child Support Agency request for a change of support payment location pursuant to USSA Section 319, and the letter of transmittal requesting registration, and that's only if it's a 4D case. The form is optional for the Transmittal 2 and the Transmittal 3. So to give you a little background on that, the Child Support Agency Confidential Information Form is intended to safeguard the privacy of individuals in a child support case by recording their PII on a separate document, therefore eliminating most PII from other intergovernmental forms. This form is for child support 4D agency use only, and it's not to be filed with the tribunal or provided to the other party. It records information that the responding 4D agency needs to provide services in an intergovernmental case, but they may pose significant risk if disclosed inappropriately. Federal and state safeguarding and privacy requirements govern the use and disclosure of the information. So in comparison, the new personal information form for USO Section 311 is required for the Uniform Support Petition, the Declaration in Support of Parentage, and the General Testimony, and may be used in both 4D and non-4D child support cases. While some of the data on this form is the same as that on the confidential information form, it's used for a different purpose. So the new personal information form for USO Section 311 records the PII required by USO Section 311 in a separate document in order to safeguard the privacy of individuals. USO Section 311 requires a petitioner in a USO proceeding to establish a support order, determine parentage, or register and modify an order to file a petition or similar pleading. This pleading must contain certain identifying information. Consolidating the required PII on one form eliminates repetition of this sensitive information. This form is filed with the responding tribunal and may be disclosed to the parties unless accompanied by a nondisclosure finding or affidavit. Because the form contains PII that may pose significant risk if disclosed inappropriately, the form should not be filed in a public access file.
Thank you, Debbie. Yes, the confidential information form for helping you build a case and UIFSA 311 obviously are required by UIFSA. We have a related question also that asks, do the Child Support Agency confidential information form and the personal information form for UIFSA 311 need to be attached when sending Transmittal 1 to a responding jurisdiction that uses tribunal enforcement? And I take that to mean administrative process or administrative enforcement. Debbie?
Yeah, so the Child Support Agency confidential information form is required when sending a Transmittal 1, period. If you're sending a declaration in support of establishing parentage, the general testimony, or the Uniform Support Petition with the Transmittal 1, then the personal information form for USO Section 311 is also required. And that's the way things handle out. So when you're doing a Transmittal 1, regardless, the Child Support Agency confidential information form needs to be attached.
Thank you, Debbie. Another question about the Transmittal 1 and the acknowledgement says on Section 1 of the Transmittal Number 1, it says, please return the acknowledgement form. Does that mean that the acknowledgement now has to be sent separately from the Transmittal 1?
Yes. As a result of the Intergovernmental Form Revision process, the Transmittal 1 acknowledgement is now a separate form. So the responding jurisdiction either generates this form to acknowledge the receipt of the Transmittal 1 or sends a SESNET acknowledgement. This change allows the responding jurisdiction to generate the form from its system rather than handwrite a response.
Thank you, Debbie. And I know we have Pat here, the expert on EDE. So the next question, how do you know if a state can use EDE? Will there be a list of states that receive SESNET or EDE?
There is state-specific information on SESNET on the OCSE website. Under the Child Support Professionals heading, select Systems, and then Federal Systems and Services. Under Child Support Enforcement Network, you select the SESNET state contacts and exchange program information. And there you will see lists of which states can exchange which functional areas with other states. So that gives you a hint as to whether or not those states have those functions open. So hopefully that will help. And the website there is a website provided, and we'll be providing that out with the responses to these questions. In terms of information, yeah.
Pat, I'm sorry, this is Courtney. We also, with the technical support team, we also just put a new updated map of the EDE states that are currently on EDE, as well as the documents that they've agreed to provide and the contact information, and it's on the helpful information section of the portal welcome page.
Right,
and
thanks, Courtney.
Updated yesterday. Mm-hmm.
Yeah, thanks. That's the second part. That's the second part of the answer. But for all of you who have access to the portal, and every state does, that's what Courtney was referring to. There's a map of EDE participating states, and it provides the kinds of documents that those states can provide. So we are expanding our state participation in EDE. I think we're at 23 or 24 now, with more states beginning to participate. So hopefully everyone on the call will be on EDE soon. And I saw an earlier question that asked, what does EDE stand for? And EDE stands for Electronic Document Exchange. And the short explanation is it's a scanned version of your hard copy document. If you have a hard copy, you scan it in and upload it, and the other state can receive it. So it's kind of that simple.
Thank you, Pat. We still have some time left. We'll go on to another question. Where will this webinar recording be available?
Okay, so OCSE is planning to post recorded training on the OCSE website in the coming months. The PowerPoint presentation, the slides and the notes are available on the website now, but we're looking at putting the recorded training on the OCSE website, so just keep looking for that. We'll announce it when that happens.
Thank you, Debbie. We'll go on to another question about the Child Support Agency Confidential Information Form and paternity. On the Child Support Agency Confidential Information Form, what box should be checked when it is unknown how parentage was established?
So if the state doesn't know how parentage was established, they would check the other box and write unknown as an explanation.
Thank you. Another paternity type question. It was mentioned that this form can be used to document the determination of paternity fatherhood. Does that mean states are no longer required to attach additional documentation, for example, a birth certificate or paternity affidavit?
Okay, so a state may share paternity information on the Child Support Agency Confidential Information Form with other states for the purpose of data reporting. The properly completed form serves as legal documentation for OCSE audit purposes. If this information provided is consistent or contradictory, and if the form is incomplete, or if the form is blank, the OCSE auditors will request other type of supporting documentation in order to confirm that the paternity case was properly reported. So I would contact OCSE if you have any questions about the reporting. However, some states or tribunals may require copies of the birth certificate or birth records or paternity affidavits.
Thank you, Debbie. We have one last question left over from session 1 about SESNET. Which SESNET transaction should be sent with each action on the transmittal number 1?
So, Pat, I'll answer that, and you can jump in if you want to. Each state determines the use of their SESNET transactions for the transmittal 1, consistent with state programming for other SESNET transactions. Since SESNET decisions vary from state to state, I would recommend that you consult your state for guidance.
This is Pat. Just as a follow-up, I know the question has been asked a number of times, and OCSE is looking at if we can provide some additional guidance in that area. But for right now, I would suggest looking at the SESNET transaction functional matrix, because that guide will help you crosswalk the activity you're trying to perform or the request you're trying to make of the other state and the corresponding SESNet transaction, which is, I think, what some states are asking for us to provide that crosswalk in a, a 1, 2, 3, 4 kind of listing for you.
Yes, exactly. Thanks, Pat.
You're welcome.
Can we check the phone lines again? That's the questions we had left over from session 1. So are there any other phone or questions on the phones?
As a reminder, if you'd like to ask a question, please press star 1 on your touch-tone phone.
I do see a reminder online here that must come from a tribal source to just remind the state agencies that most tribes don't have access to either EDE or SISNet, so that's a good thing to keep in mind if you're working with a tribe.
And no questions on the telephones then?
I am showing no questions.
Okay. And we have no more questions online. Could I see the last slide, please? Please use the email address on this slide to submit any additional questions. And remember that these slides and notes will be available soon on the OCSE website. I think we're letting you out a little bit early today, and that's good. Thank you to all of you for attending and for the great work you do, and we'll see you in session 3. Thank you.
Thank you for joining today's conference call. You may disconnect at this time.